Hi Con Law class, this is Professor Opterbeck and continuing our series of review videos, and this will be part one of a review from week 8 when we began to look into due process. And the first thing we looked at was the sources of due process, and in the Bill of Rights we have a due process clause in the Fifth Amendment, and then in the Reconstruction Amendments in the 14th Amendment we have a due process clause in the 14th Amendment. So we then began to look at, well, what is the substance of the due process clause? We've touched a little bit on some of the procedural aspects of due process, notice and an opportunity to be heard, and so on, but what, if anything, is the substance of due process? And the first place we looked was in this area of economic liberties. And we talked about the idea of, well, what does due process really mean in the tradition, and really kind of a jurisprudential difference of this kind of English natural law view that due process recognizes inherent rights of the people that pre-exist even the constitutional document, or a structural view that says the written constitution really is primarily setting up the structures and procedures of government and is not, unless it expressly does so, incorporating these pre-existing rights. And this idea of this natural law tradition we saw in the economic arena in the Lochner case. So recall that this is a case involving the working hours of bakers, and the court at that time says the general right to make a contract is part of the due process liberty of the 14th Amendment. He frames it in terms of, you can work as long as you want to work. You can make a contract to work as long as you want to work. Some interesting dissents in the case. Justice Harlan suggested that the freedom to contract could be and should be subject to reasonable police power regulation. Justice Holmes said the 14th Amendment is not trying to enact Herbert Spencer's social statistics, in other words, kind of a particular view, a laissez-faire kind of view of the way the world ought to work. But at this point, Peckham's opinion carries the day, and for a period of time in our constitutional jurisprudence, the freedom to contract is viewed as a fundamental substantive right. Now, we noted that this begins to change in significant part because of the effects of the Depression, and as we looked at the New Deal legislation back when we talked about the Commerce Clause, it pops up again here, because now you have legislation that's designed to remedy working conditions, wages, all those sorts of things as part of the New Deal. And those things are getting challenged and are pushing up against this rule in Lochner. And so we see a set of cases that really push back and basically do away with Lochner's reasoning. So one of those cases is Nebbio versus New York. Remember that this is a case involving the milk industry and regulation in the milk industry. And the court here says that property rights and contract rights are not absolute. They're matters of private concern, and there is a proper space for regulation, and that due process really only requires a kind of reasonableness, that it not be unreasonable, arbitrary, capricious, and that there's a substantial relation to the object attained. This is sort of the very lowest level of constitutional test, a kind of rational basis sort of review. We saw this also pop up in West Coast Hotel versus Parish. This is a case, remember, involving wages in the hotel industry. And again, the court says here that the Constitution doesn't recognize an absolute right in the right to contract, and that other important interests like the health of the women working in the industry may sometimes trump that right of contract. We noted that there always were lines of dissent. Remember, we referred to the Four Horsemen, the parts of the court that were opposed to the New Deal, and who said, we can't let the meaning of the Constitution ebb and flow just because of economic events. But at this point, their view does not carry the day, and in the majority view, it's really just a rational basis review of economic legislation, and that really remains the rule today for economic legislation. We saw, however, some continuing murmurings about the way this review might be more extensive in other areas beyond economic. And so in U.S. v. Caroline Products, and remember that's a case about milk and the way milk is marketed, rational basis review was applied by the court. The court said, whether this kind of commerce is potentially confusing consumers and should be regulated is really up to Congress. But remember, there was that footnote 4 in Caroline Products, and in that footnote 4, Justice Stone says, well, there might be other cases when there are places where there are groups who really don't have access to the normal political processes that need to be protected. So if we look at milk producers who are being regulated, they have some economic clout, they have some ability to influence legislation and deal with this at the political level if they want to. But if we have a group that is in some sense disenfranchised, either literally or sort of effectively, then we might apply a more searching kind of scrutiny. And as we have seen, we see that notion play itself out in other aspects of the constitutional jurisprudence. We saw how the rational basis test gets applied in Williamson v. Lee Optical. And one of the things we noted in this case was that the court, when it's applying rational basis to economic legislation, it may find evidence in the record, sort of in the legislative history of what Congress intended and what the basis is. It also might kind of search for a rationale and might even come up with an ex post justification. That is something that maybe even Congress didn't directly think about, but is just a reason why it can be rational. It illustrates how difficult it is to nullify a piece of economic legislation under rational basis review. We then kind of shifted from the economic sphere to the sphere of privacy, and we saw that the Lochner tradition of looking at some kind of inherent, natural, even perhaps pre-constitutional right never entirely went away. And we looked at a number of cases where there were things that weren't exactly economic and that maybe got to get a little bit closer to sort of a person's identity or freedom or speech or other things like that. So Meyer v. Nebraska, a law against teaching German in schools, Pierce v. Society of Sisters, a law that required children to go to public schools and not parochial schools. Skinner versus Oklahoma, compulsory sterilization. We talked a bit about that sort of line of different cases involving the eugenics movement. And we saw in all of these cases kind of the notion being kept alive that there are areas in which perhaps this sort of natural rights tradition or this more substantive tradition, something beyond a rational basis review, might apply. And then we saw that really come to fruition in Griswold v. Connecticut, which you'll remember is the contraception ban case. So remember that in that case, Justice Douglas says not all of the guarantees in the Constitution are explicit in the Bill of Rights, and he talks about this idea of penumbras and emanations from the Bill of Rights of further things that might be protected. And he mentions a number of things that he believes the court has already put into that space, and he talks about this sort of zone of privacy that's protected by the Bill of Rights. We talked a bit about what this metaphor of penumbra means, and if you remember, it's kind of helpful, I think, to just sort of picture it, that it's, the shadow that's cast, sort of the dark part of the shadow is the umbra, the fuzzy part of the shadow is the penumbra. So it's this space that's a little bit unclear, that's a little bit fuzzy, but which you might discern the light kind of breaking through a little bit. We noted the line of number of dissents in the Griswold case that sort of reflect continuing tensions that different justices will talk about in substantive due process today. Concurrences and dissent. So Justice Goldberg talking about, well, we really should be talking about is what rights are fundamental, and we should be looking to the Ninth Amendment for support. We have Justice Harlan saying, let's not try and use this language about penumbras. Let's not try and look for specific rights in the Bill of Rights, but let's ask about basic values. What is the concept, the basic concept of ordered liberty? And so we see that thread playing through as well in some of the due process jurisprudence. And for the dissenters, as you might expect, they say, well, really this is just another kind of Lochnerism. This is an effort by the Supreme Court to sort of assert itself where the Constitution doesn't really assert itself, and that's something that the court should avoid. Of course, the majority in Griswold carried the day, and that thread, whether it's sort of the penumbras and emanations or implicit and ordered liberty kind of line, has generally carried the majority in these substantive due process cases involving things like intimate relationships. We saw then how this played out in the abortion context, and so we talked about Roe v. Wade. We talked about the basis for Justice Blackmun's opinion in this idea of a right of privacy, and how he suggests that this right of privacy is broad enough to cover the woman's decision about whether or not to terminate the pregnancy through abortion. He noted two state interests, the interest in the woman's health and the interest in protecting potential life, and he suggested these interests may become sufficiently strong at some point that they would justify greater state regulation. And so Blackmun comes up with his infamous trimester framework, and he decides that basically around the first trimester of pregnancy, the decision is generally left up to the medical judgment of the woman's physician. Notice the language that he uses there. In the first trimester, after the first trimester, the state can step in and regulate in ways that are reasonably related to maternal health, which would really be in the second trimester and later. But then after viability, which Blackmun thought was around the beginning of the third trimester, the state can regulate or even prescribe abortion, except where it's necessary in the medical judgment of the physician for the preservation of the life or the health of the mother. So notice this kind of sliding scale of ability of the state to regulate based on the trimester of the pregnancy. Of course, there are dissents in the Roe case as well, and these, again, fall along kind of familiar lines that there's really nothing in the Constitution about this, that it's something that ought to be left to the states and to the legislatures, and that it's a very difficult decision that shouldn't be decided by the court. Well, as we talked about, there's lots of litigation, lots of legislative activity, many things going on in this area of abortion, and it was thought by the time this issue gets to this issue of a waiting period and other kind of restrictions that are being put in and around abortion gets to the Supreme Court in Casey, that some pro-life advocates thought that the court might be willing to overrule Roe. But somewhat surprisingly, Justice O'Connor was the swing vote and decided not to overrule Roe. But remember, as we looked at Justice O'Connor's opinion, it's not entirely clear whether or to what extent the Roe framework remains intact and what exactly is now the constitutional test for restrictions on abortion. So we have a bunch of language from Justice O'Connor about her view of the relationship between abortion and the kind of dignity of the mother. She recognizes that there have been changes in technology that perhaps call at least parts of the Roe framework into question, but she suggests it's not entirely unworkable. And she really seemed concerned about not overruling under fire, about not, in her view, diminishing kind of the authority of the court by overruling a precedent like Roe. But O'Connor recognized that there were places in which the state could regulate, that this liberty is not absolute in a way that does away with all state interests, and which he really seems to come up with is an undue burden test. So if the regulation has the purpose or effect of placing a substantial obstacle in the path of the woman, it could be invalid. And so we have some questions about, well, what exactly would constitute an undue burden? As applied, in this case, Justice O'Connor said, well, the information disclosure provision can be okay, a waiting period can be okay, spousal notification would be invalid, parental notification would be okay. so long as there's some kind of judicial bypass. So you can see in the way that O'Connor applies her idea of an undue burden about how that might fall out in different kinds of restrictions. Again, concurrences and dissents. Justice Rehnquist's partial concurrence says, well, this really is a retreat from Roe. Forget about all Justice O'Connor's language about stare decisis. It's really doing away with Roe. And really shouldn't think of abortion as a fundamental right because there's another life involved. There's the life of the fetus involved. And if the court realizes that it's wrong, it ought to correct its mistakes. Justice Scalia also saying, it's kind of one of his kind of classic partial dissent, partial concurrence here, that he doesn't think Justice O'Connor's opinion really holds together at all. You can see those fracture lines that continue on these issues in the court. We then looked at how this jurisprudence continues to develop, and Gonzales was the intact D&E or partial birth abortion case. And here, a conservative bloc attained the majority and said, as a facial challenge, we will say that this ban is not unconstitutional. And said, well, maybe in a particular as-applied case, it could be unconstitutional, but on its face, not unconstitutional. Using here kind of the Justice O'Connor's undue burden framework and saying that this does not pose a substantial obstacle because there are other procedures that are equally available, and that it's appropriate for the government to use its voice in a circumstance like this to suggest its respect for life. So notice here that the conservative bloc is picking up on Blackmun's language in Roe about the state's interest in potential life. And as we'll see, Justice Ginsburg and the liberal bloc of the court really wants to move away from that language and focus primarily on the woman's health. And so here's Justice Ginsburg dissent. Justice Ginsburg says, really, when we're talking about abortion, the only focus we ought to have is the health of the woman. And if there's any potential impact on the woman's health, or if it's not reasonably related to the woman's health, the restriction, in her view, should be done away with. That led us to the Hellerstedt case, and Hellerstedt was a case involving admitting privileges and surgical center requirements. Remember, this is a way of, as we discussed in class, really probably a lot of what's underlying this is a way of attacking Planned Parenthood, because it would require hospital kind of requirements for abortion clinics. And here the liberal bloc had the majority and said, look, these provisions don't really confer the kinds of medical benefits that would really benefit women. There was evidence at trial showing that these provisions really were unnecessary, and that they led to substantial closings of abortion clinics in Texas. Justice Ginsburg, again, reiterating her theme that really any restriction on abortion or any rule related to abortion has to be all about the health of the woman. So this is the first part of the review for this section. I'm going to do a separate review for the cases involving homosexuality and same-sex marriage.